Hello everyone, welcome back to our channel. Today's video is about marriage issues faced by NRIs. We will discuss what remedies are available if an NRI has facing any marriage issue and where such cases can be filed in India. So our first question is, can NRI obtain mutual consent divorce in India through video conferencing? So answer is yes. An NRI can obtain mutual consent divorce in India through video conferencing without appearing in court. But there are certain requirements, steps and court practices to follow. So let's talk about the summary of how it works under current laws and what are the legal procedures. The relevant provisions is under Section 13B of Hindu Marriage Act 1955. It allows a married couple to seek divorce by mutual consent after a cooling off period, provided that there is an agreement of both and the court is satisfied that marriage has irrecoverable breakdowns. The Madras High Court in October 2024 ruled that estranged couple need not to present physically in the court at either the filing or hearing stages of mutual consent divorce. They may appear through video conferencing in the court. The court also allowed the petitions to be filed through power of attorney holder. Court have permitted to one spouse to grant a special power of attorney to another person so that that person can handle filing and appearance, in some cases representations. Judges and high courts emphasized that insisting or physical presence can be impractical, especially for NRIs, and that video conferencing is a legitimate mode to allow access to justice. Even when court allows video conferencing power of attorney, then there are certain requirements that has to be followed. The court must verify identity proof and address of the parties, often through affidavits and notarization from Indian Embassy from abroad. The power of attorney must be widely executed and registered. Both parties must consent truly. The court will check that there was no coercion or fraud between the parties. Cooling off period between the first joint petition and the second period, often 6 months unless waived under special circumstances or by court approval if legal precedents allows. Settlement terms must be agreed, like maintenance, alimony, child custody and division of property. So second question we have, one partner files divorce in abroad and one partner filed divorce in India. Does it mean there are two different cases? How court can work on it? Yes, technically two separate cases can exist. One case filed by one spouse in foreign country and another case filed by another spouse in India. However, both will allow to proceed. One will be considered final. Depends on the recognition of foreign divorce decree in India. Conditions for recognition of foreign divorce decree in India. Under Section 13 of Code of Civil Procedure and case Narasimha Rao versus Venkata Lakshmi 1999, a foreign divorce is recognized in India if jurisdiction was proper. The foreign courts must have jurisdiction according to the Indian law, such as last matrimonial home, domicile and consent of the parties. Second, notice and participation. The other spouse given the notice and had a chance to participate. Ex parte foreign divorce usually not recognized. So our third question is it divorce and maintenance are same thing or different? Is it linked with each other? Then answer is divorce and maintenance are two legal remedies. Divorce is a dissolution of marriage and maintenance means financial support to the wife or child or sometime husband. Under Hindu Marriage Act 1955, Section 13 talks about contested divorce and Section 13B talks about mutual consent divorce. Hindu Marriage Act 1955, Section 24 and 25 talks about interim alimony and permanent alimony. Under Section 144 of Bharatiya Nagrik Suraksha Sanhita, there are quick remedies for wife, children if they are unable to maintain themselves. So, even if there is only one divorce case, a spouse can separately or simultaneously claim maintenance. Recent reforms and judgments make it clear that divorce is an independent right and not dependent on whether divorce succeed. In the case of Rajneesh versus Neha 2020 issued guidelines on maintenance, both spouses must file affidavit of income, assets and expenditure. Maintenance is a right to prevent destitution, not a favor. Overlapping maintenance claims in different courts should be adjusted. In the case of Amardeep Singh versus Harveen Kaur 2017, 6 months waiting can be waived if the marriage is irretrievably broken. It affects speed of divorce but not maintenance right. Domestic Violence Act 2005 monetary relief can be sought even without divorce proceedings. So our fourth question is, NRI husband left his wife in India and gone abroad. So what legal remedies and legal actions wife can take? A wife can still file a divorce under Hindu Marriage Act 1955 or Special Marriage Act 1956. Court may grant permanent alimony. So here are NRI specific safeguards. Ministry of External Affairs helps abandoned wife by taking up the case with foreign missions. Passport Act 1967. Court can recommend cancellation of husband's passport until he appears. If you found this video useful, then don't forget to like, share and subscribe NRI Legal World. Thank you.